Welcome back to the channel. Today's docket is a quiet powder keg, People v. Samuel Peoples. In the next few minutes, you'll watch a judge juggle competency proceedings, bond violations, and the surprisingly tricky world of GPS tethers, where a single anxious decision can upend a release plan. The prosecution comes in asking for a forensic exam to evaluate competency, while the defense tries to hold the line on home confinement after a tether tamper that, crucially, didn't end in flight. The judge's tone? Firm, pragmatic, and laser-focused on safety, accountability, and treatment access. Big questions ahead. When mental health crises collide with technical violations, what's the fairest path? Custody for control or community-based monitoring with guardrails? Stay locked in. There's a pivotal bond call, a reality check on who pays for damaged equipment, and a tense moment when courtroom decorum almost derails the flow. Watch for the judge's balancing act between public safety, defendant stability, and due process. It's courtroom triage at its finest.
You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber. Court does call the cases of the People versus Samuel Peoples.
Thank you, Richard. People.
And Alex Warren Green on behalf of Mr. Peoples. State your name, Sam.
Samuel Peoples.
Your Honor, in file 1326, Mr. Peoples has not yet been referred to the Forensic Center. I've prepared an order, and we are asking the court to order a forensic examination in that case.
Legal decoder. A forensic competency examination asks whether the defendant understands the proceedings and can assist counsel, not whether he's guilty. Ordering it now pauses momentum on the merits to get the mental fitness answer right. Notice the scheduling friction, dates flying, a past last week competency date, and then a reset to October 2025, 9 a.m. That's not a plot twist. It's a reminder that mental health evaluations ride on availability and logistics, not just urgency. Engagement question. Should courts expedite competency in every tether case, or does careful evaluation justify the slowdown? The judge's move here protects the record. If competency is in doubt, every later decision, from bond to plea, has to rest on solid ground. Good process now prevents appeal fodder later.
All right, I will order a forensic examination without objection on that case. What is my next date? Give me. Let's see how. Because has he already started the process?
I don't believe he's been interviewed, Your Honor. The competency hearings on those matters are October 30th.
It's just last week.
That was last week. All right. So set a competency here, October 2025, 9 a.m. All right. What are we doing on the other case?
Your Honor, in the bond violation matter, we'd ask to continue our plea of mute at this time. That bond violation arose from the charges he is now facing in the felony case 1326.
Well, also arose from the tether.
Which is charged as a felony, Your Honor.
Sergeant.
Ms. McDuffie apprised the court that there is a tether tamper, which gave rise to the bond violation. He has been charged with a felony for tether tampering, so I think at this time
He has been?
He has, yes, Your Honor.
That's the new one.
There is an error on the complaint. We are having that amended. It should be a general tamper versus the category that's listed.
Yeah, this is wrong. Okay. All right.
So we would just ask to continue our plea of mute and continue these cases to the competency hearing on.
So is he just going to remain in custody?
Your Honor, he's working with a social worker. We are asking, or between now and October 30th, we are hoping to file a written motion. I think something substantive that gives the court a better idea.
What's the objection in releasing? I mean, the thing is that as I understand the cut on the tether, he cut the tether, but he didn't go anywhere. Or I'm saying, yeah, worse, he cut the tether. I'm not. But he didn't go anywhere. He was right there when they went to go get him.
That's my understanding as well, Your Honor. If the court would consider it, then I'd ask that he be released back to home confinement.
I had a lot of anxiety.
Response?
Your Honor, obviously we had an extended conversation about this at the last hearing. I don't have any objection to him remaining on the conditions that he was on prior to this incident. I'm concerned that, given that we have this incident, I don't know how sufficient that's going to be, but I'm fine with him returning to home confinement for previous terms.
Mr. Peoples, if I let you go back home, you're gonna cooperate and do the right thing?
Yes, Your Honor.
Okay, that means you can't tamper with the tether.
I understand now.
You understand that?
Yes.
Or you understood it before you just did it?
I had a moment of anxiety that led to a freak out. Yes. And I felt like I needed to get it off me.
Here's the heart tug mixed with hard law. The defendant admits anxiety led to a freak out in cutting the tether. Two facts matter. 1, he didn't go anywhere and was found right away. And 2, the tamper still triggered a new felony charge and this bond violation. The judge tests a key principle. Is non-flight tamper a fixable lapse or a flat disqualifier? Defense pivots to home confinement again. Prosecution surprisingly doesn't oppose returning to prior conditions, just not a tracking tether upgrade. The judge floats restitution for the damaged strap and asks whether the family can cover it, a practical bridge between accountability and release. For viewers, tampering is serious, but context, no absconding plus crisis, can tip the bond calculus towards structured freedom with consequences.
Because it was claustrophobic and
Got it.
yes.
I hear you. Okay. All right. Here's gonna be part of the issue. I don't know if there are funds available to try to deal with the payment for that strap. Do you know family-wise whether that's available?
Your Honor, we have been in contact with his family. It's certainly something I can ask them.
Pardon?
It's certainly something I can ask his family. They are here today.
They are here.
That's correct, Your Honor.
All right. Samuel,
Yes, Your Honor.
I give you another shot. You're gonna try to do the right thing?
Yes.
Okay.
Thank you, Your Honor.
All right. I'm gonna do it. I think you can do it.
You too.
Okay.
All right.
Got it?
Thank you.
So what's gonna have to happen is somebody's gonna have to pay money for the strap that got damaged on your tether.
Understand.
I'm gonna reinstate your previous bond where you were previously at home, right?
Mhm.
And then they'll have to do that because you don't have a tether on now, right?
That's correct.
Okay, so they'll have to fit you with a new one prior to your release.
All right. Thank you, Your Honor.
Okay. Don't let me down. You hear me?
Yes. Yes, sir.
Your Honor, may I add one thing? After
Sure.
consulting with Mr. Peoples' family, they are asking the court if Mr. Peoples has any kind of crisis or something like that, if he can be transported to Trinity, Ann Arbor, without necessarily violating a confinement order. I know it's tricky to do, but they can alternatively contact me and I can talk to the tether agent if that arises.
Response.
We addressed this, I think, at the last hearing. If Mr. Peoples needed to get seek help at the hospital, that wasn't going to be an issue regardless. He would just they would simply need to notify community corrections of what happened and where they are. And if there were any sorts of deviances from the home confinement zone, I think that was the plan, which was to immediately notify community corrections office, so that the court would be apprised of what was happening. But the tether conditions, I believe, want to remain the same.
Actually, what happened last time was the public defender came up on our Mr. Peoples' behalf with a communication from CMH and a request, I believe, from his family that they're aware of certain triggering events for Mr. Peoples. That on those triggering events arising, what they were looking for was some leeway from the court to allow them to take what action, not necessarily, I mean, if they had to go to Trinity, that's fine. That's a medical thing at that point. But from what I understood and what was explained to the court, sometimes it may just be a walk just to kind of bring him back and to do whatever. I mean, I'm not using medical terms, but yeah, I think you get what I meant. My understanding is, as we were looking at that, is the people were absolutely not in agreement with that.
That's not correct, Your Honor. The request.
Well, that's what you said.
The request for.
That's what you said at the bench. If you're telling me I'm wrong, then you better be clear, Jade, right now.
This is a two-parter, substance and tone. Substance. The family asks for a humane carve-out. If a triggering event hits, can they take him for a walk or to Trinity Ann Arbor without auto-violating home confinement? The judge recalls a prior bench exchange and pushes for clarity. The state opposed a tracking tether, but what about brief, documented deviations for de-escalation? Tone. The court reasserts control with, "Stop talking," and "You huff one more time." A reminder that decorum isn't theater. It protects the record and keeps high-stakes decisions from being made in chaos. Engagement. Do you favor rigid confinement to deter future tampering or structured crisis flexibility with immediate notification to community corrections? The answer determines whether supervision is punitive or stabilizing.
I will be clear right now, Your Honor. What I said was no to the request for a tracking tether, not for home confinement. That's what I disagreed with.
When he asked whether or not they could leave, you objected vehemently, which is why I came to the decision that what I was going to do was I was told and I made it very clear, we'll bring him in here, because what I told him very clearly is, fine, you can ask for permission, but maybe we're just in a situation to ask for forgiveness. Let the family do what they need to do. That's what you said. That was your objection.
I'm not disagreeing with that part. The request is for a tracking tether change.
Stop talking. You huff one more time and we're going to have a problem. Childers, McDuffie, Mr. Brown, Miss Yagi, my chamber.
Your Honor, I'm very familiar with Mr. Peoples' case that the court wants to proceed.
All right. Ms. Douglas is now here on behalf of the people on this one. So I think we can finish this up. Here's what I'm doing. His new case had $100,000 bond. I'm going to make his bond in his new case match the bond with the conditions in his other case, so that he can be released, because otherwise he would be held on that. He'll be refitted with a tether on, he'll be refitted with a...
Big ruling. The judge aligns the new case's bond with the older case's conditions so the defendant can actually be released. Otherwise, the new $100,000 bond would keep him locked in despite today's compromise. Conditions return to GPS home confinement with a refit before release, and the family covering $175 to community corrections and responsibility for the damaged strap. This is classic courtroom problem solving: public safety via monitoring, accountability via repayment, stability via access to care, and clear reporting if a crisis requires travel to the hospital. Pro tip for viewers: these dollar amounts aren't random. They ensure agencies can replace equipment fast, reducing downtime and risk. Question: would you make the same call, release with costs and tight conditions, or hold until competency is complete?
GPS home confinement tether prior to release. My understanding is the family can pay the $175 to community corrections, so they'll get that paid, and all prior conditions are reinstated. And then we need a new date. So when do we?
Your Honor, my request.
Well, I got the competent. It's actually going to be October 30th.
Okay.
It's going to be our day. So, all right.
Thank you, Your Honor. May I provide the court with the order to undergo forensic?
There hasn't been enough on this case yet, Mr.
I'm not.
No, go ahead.
May I approach?
Yes.
Thank you.
What is this? No, that's
Thank
the
you.
order on the other case. I'm sorry. Not a problem.
Might be tomorrow, but as soon as they put the feather on you.
Okay.
Okay. Sounds good.
Okay. Anything else on this matter?
Nothing from the defense, Your Honor.
All right. And Samuel, you told me you're going to do it, right?
Yes, Your Honor.
Today's takeaways. The court ordered a forensic competency exam, kept the case anchored to an October competency date, and, despite a tether tamper, reinstated home confinement with GPS refit before release. The judge blended compassion with control, acknowledging anxiety and claustrophobia while demanding payment for damaged gear and strict notification if crisis care is needed. Prosecutors didn't block a return to prior terms. Defense secured a workable path that keeps treatment front and center. The message is clear. Mental health crisis is a factor, not a free pass. You get structure, not a shrug. If you found this case as illuminating as we did, who do you think got it right? The judge's balanced release, or should custody have continued until the exam? CTA, if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Thank you.
Court does call the case People versus Monica Collins.